This is open to the public comment other than
Well, it was.
Yeah, me too.
Would anyone like to speak? Okay. Ms. Nicholson first, and then Lisa herself. Please come up. Please tell us your name.
Can you point the speaker up the microphone?
And the subject.
I'm Dave Nicholson. I'm here tonight with the Citizens for a Healthy Salmon Creek Watershed. We filed an appeal last Monday, December 10th, of the issuance of a building permit to the Lansing Gun Club for the expansion of the track fields. Then recently, because there was no stay upon appeal imposed, we sent to all of you an email requesting a restraining order for the gun club to cease continuing to build their planned expanded track fields. Have not heard back from anybody from the ZBA. So we're here tonight to talk to you about that stay upon appeal. New York State Town Law, Article 16, 267-A.6 states, stay upon appeal. An appeal shall stay all proceedings in furtherance of the action appealed from. That's the important phrase in this part of the law. It's the default. When an appeal is filed, the action of that proceeding must be stayed. That's the norm. That's the default. Everything else is unless X, Y, and Z happens, unless the administrative official charged with the enforcement of such ordinance or local law from whom the appeal is taken certifies to the Board of Appeals, etc. It's all been provided to you in writing. So since the code enforcement officer did not certify to the Board of Appeals a reason for why the gun club should be allowed to continue to build under this, what we feel is an unlawfully issued building permit, we would like you to intervene and have them stop. Since the hearing is not scheduled until January 29th, it gives the gun club ample opportunity to completely finish building their new expanded track fields, making a second hazardous waste site in the town of Lansing. By default, we've allowed them to win. What's the point of having an appeal and a hearing if they're allowed to carry out the action? So we ask you to instruct the code enforcement officer to issue that stay.
Sir?
She can go next.
Okay.
Hi, I'm Lisa Rosita, and I'm here to talk about the appeal.
Is that microphone
Can't hear
working?
you. Can't
Speak right into the mic.
Speak right.
Bring it closer.
Yeah, get way close.
I'm here to talk about the appeal that got filed on the 10th of December to rescind the Gun Club's building permit. On the 11th of December, I called Lynn and Dale to inform them they were still working over there. It was our impression they would stop as soon as the appeal was. And I wanted to know why that hadn't been done. Yes, the town lawyer, if they had to do that. If we knew of any law as to why they should stop till I had done. That's when the government about it. So, I don't, it's my understanding that you have to give public notice and let the public know that you appeal is not even being considered. It's almost as though you've already given permission for the Rock Gun Club to have their track ranges.
Would you like to speak to her or text you?
Oh, you can probably hear it in my voice. How it affects me ever since I learned about it 12th of March. This is going to run our property value. And it's
Right next to it.
They will be 500 feet from our shed, within 3/4 of an acre of land. The noise will be unbearable. They, repetitive shooting next to our house on the weekend when we're off work too, trying to enjoy ourselves. We think that we're going to, our property value is going to be diminished. And we're not going to want to live there because the quality of our life and our happiness and our health with lead dust in the air. My hobby, gardening for years, which I'm no longer able to do. Shooting into a wooded area too, where bullets can ricochet around. I mean, this whole thing has already taken a great toll on us.
Thank you.
Thank you very much.
Thank you.
I'm not going to talk about the appeal. I'm more interested in, I've studied this.
Can you state your names?
Yeah, Stephen Smith, Ludlow. I'm more interested in, I think the vibe I get, the town said, well, if the EPA says it's okay, we're okay. Or if the DEC says it's okay, we're okay. Well, that, if you read into it with gun clubs, when they try to readjust how they're going to fit into a town, usually it's a zoning board of appeal that makes the decision on, how's this work with our town, Should we try to push them towards, trying to get along with everybody, or are we going to let it, because when it first started, it wasn't a gun club like it is now. But anyways, there's about 200 ton of lead loose someplace, but I just read this is hot off the press, and as my girlfriend says, if you look for something long enough, you'll find it. And this article's about December 7th, 2018, is why is lead polluting more than 100 South Carolina waterways? And they're saying, is it dangerous? And, it goes on, don't worry about it, but don't eat the fish, and, all sorts of, there's stuff coming out all the time. And, again, the EPA, they said, well, the EPA said it was okay and all that, but again, I'll just leave this here. It's from the state. This isn't a national inquiry. This is some kind of South Carolina magazine. But again, I can't emphasize enough that you can't, the state of New York has always known about it, and they're in with the gun clubs. They just don't want to mess with that situation. And the EPA, they said, well, as long as you're not, they were a little upset when it was dumping into the creek, but you know what I mean? If you read any of their manuals, it isn't there, but in the end, it's a local decision. It's not the EPA isn't going to come in and decide what's good for the town or anything like that. They never do that. So it usually ends up with a zoning board of appeal if you look into gun clubs and how they fit into a town or not fit in, or what do they have to do. So it's up to you guys, not up to the EPA. And the EPA is he's got a 100 rating or something with the NRA, the head of the chief of the New York division. He loves guns. So the DEC just doesn't want to deal with it, and so, but I don't know if you can eat the fish in Salmon Creek or not, but according to this in South Carolina, they're wondering where the lead is, and they're not happy, so that's my spin.
Thank you. Karen?
Hi, I'm Karen Edelstein. I live about 2 miles up the road from the gun club. I'm a trained street ecologist and have done a lot of mapping work to support the Citizens for a Healthy Salmon Creek watershed. I don't know if I can add a lot more to what Gay and Lisa and Steve have said, other than that so much of the direction in which this goes rests on this very board that I'm sitting in front of. While the town officials have essentially sat on their hands and let this thing continue to move ahead, we're looking at this appeal as a first step to try to protect the health of both the environment and the human inhabitants in Ludlowville, particularly Lisa and Tim. But it goes much further than that because of the use of that stream by anglers and by families with small children. We understand that that appeal is meant to stop the construction as it is right now. The problem that we have is not so much just the construction of the trap things that they're building, but the fact that how this whole process has been so dramatically segmented. That permit was so that they could build their shelter and build their parking lot and build their little launch pads. Nobody is discussing the impact that moving that trap field will have on the larger environment. Nobody is discussing what will be the outcome of loading 3,500 pounds of lead to the environment every single year. Nobody, because we can't get past this step, is able to discuss the fact that the EPA stipulates that that lead needs to be reclaimed, and that's either done by a very expensive process of vacuuming it up off the field or using a shot curtain, which is just as expensive, but they particularly say that that hillside that the lead is going to get shot into needs to be stripped of its soil, which requires stripping the hillside of its trees so that the soil can get taken out every 5 years. So it's not just about a parking lot, this appeal. If we can look at this as an intact, comprehensive project, I really hope that this board will take seriously and even acknowledge that appeal has even gotten to. Because as far as I know, Lisa and Tim have not even received a single acknowledgement that 100 pages of carefully researched work that's been vetted by local lawyers, that lawyers, attorneys on the state level have weighed in on and believe that what we're asking for is completely warranted and valid. We're really looking to you to answer and support us. Thanks.
Quick question if I can. It almost sounds like you're starting the hearing on the appeal.
I'm trying not to, but I know these people
That
can't
bridge has
get-
been crossed,
Okay.
so I would be very careful.
Should we take any more?
If it's about a motion for a stay or something like that, I guess you could hear that, but at some point or another,
Well, we're not-
there's,
Yeah,
you don't have that, you don't have that kind of equitable injunction power.
right.
It's a determination that isn't before you. That's not what that provision says. And reasonable and unreasonable people may disagree, but we're starting to get into the underlying basis of the challenge, the issues that were presented on the appeal. You're getting arguments and you're asking people for specific invidious impacts. And those are appeal issues that are supposed to be reserved for the hearing. And you've got a due process violation if all of the parties are on notice that the hearing is started.
Okay. Well, I think at that point, we'll just have to call them in, because I don't want to put,
But we can be talking to you about this motion for the stay upon appeal tonight, correct? The stay.
There is
the
no
issue.
procedure for making motions to a ZBA.
I thought you just said that.
No, I said that issue was addressed, and it was addressed. The question was brought before you that you're being asked to order the code enforcement officer to issue a stay. The stay already exists. It stays proceedings. It's your jurisdiction, you can interrupt if you want, but I'm advising this board, and maybe we should do this in closed session if we're not going to be able to communicate. That'll be my official recommendation, that you seek legal advice from counsel on 267A6.
Could you clarify, did I hear you say that the stay is enforced?
Yes, the stay is an automatic stay. It's only when the code officer certifies, and again, we're getting into legal, so I won't go much further than this. It's only when the code officer certifies that the stay should not apply. That is a determination of the code officer that this board can review and overturn and reimpose the stay. But the stay applies to proceedings.
Not to the actual permit.
Proceedings of the action.
Proceedings flowing from the underlying determination. The exact same rule exists in village law. The exact same rule exists in subdivision law. It has a very specific meaning. It has a very specific history. And what people are really looking for is an injunction. And that's section 282. It's not section 267. It's not something that you have the power. You're the judge. You're the quasi-judicial body that's going to hear the appeal. It's not, you don't have that kind of equity jurisdiction. It's not been delegated to you. You're the judge. You're supposed to stay neutral and detached from all of this petitioning and frolicking and arguments until such time as you assemble the record and have your hearing. That's when all these arguments should come forth.
Well, in all fairness, and I don't want to taint the process, so I think we'll stop right here until we get a little further. Karen?
I would just like a point of clarification, if I could, Guy. So can you define what the stay refers to in this situation right now upon appeal?
The stay would refer to proceedings. The stay exists to protect the landowner. There is specific case law in New York State that says the stay is not applicable to third-party appeals. So you're referencing the wrong section of law and you're making your petition to the wrong board. But again, I'm going to cease giving advice to people whose interests are clearly hostile to me as well as the town. And I'm going to give my legal advice to the ZBA.
Okay. All right. I think we're going to close the public meeting. And Joe?
I hear the public worried that another month and a half is going to taint the process as well. You do have the ability to move your meeting forward so it happens sooner rather than later, so that the issues that brought up can be dealt with at a hearing, properly noticed, with the assembled documents, and maybe that's a solution you should look at.
Okay. I need a motion to close the public meeting. Second.
But if you want to go into closed session, then you should leave it open and close it after the discussion. If there's no meeting, it shouldn't be followed. Unless it's a training session, then it's not.